Okay, here I am. This is going to be a fun one. I lovingly refer to this case as the case of two Irishmen walking into a bar and changing real estate contract law, because that is essentially what happened. But this one's a great case. It really did impact how contracts are written in Massachusetts, but I've noticed that it's carried over into a lot of states. And because this is the Multifamily Law School, if you remember last time, we'll build upon what we teach throughout the weeks. But last time I talked to you about constitutional law, state constitutional law, how law was created in one state and then kind of went out to other states around it. Because this happened in Massachusetts, we've already seen, in this, especially in New England, that all contracts have picked up this case, the McCarthy v. Tobin case, and have run with it. So let me get into the facts. We're going to treat this as a real law school class, eye-racking the case, issues, rules, analysis, conclusion. We're going to start off with the facts of the case. And this is a really, really interesting case. But here's the thing. There's a punchline at the end. So make sure you stay tuned, because, there's a little curveball in there. And I want to understand. I want everybody on the call to see if they can come up with the solution to the curveball. Okay. So you've got three parties in this case. Why would you have three parties? You'll find out soon enough. But as I say, that it's known of as the McCarthy v. Tobin case, and then some Italian came along a little later. But you have to understand that what happened was McCarthy was the buyer and Tobin was the seller. And they entered into an offer to purchase, OTP, offer to purchase. Now, you remember when you're doing single family residential type stuff, you make the offer to purchase, and then that gets agreed upon. And then you go into the purchase and sale contract, which is the true document that governs the deal, or so we thought. And so what happened was Tobin and McCarthy, they sit down and they draft an OTP for $526,000. Now, this was back in 1995, I believe, that the sale took place, or the offer to purchase took place. So what I'm going to do is I'm going to pick it up and give you some of the highlights of the fact pattern so that you understand exactly what's going on. Let me see. The plaintiff, John McCarthy, claims that the defendant, Ann Tobin, good old Massachusetts Irish Catholic name, agreed to sell certain real estate to him. He asserts that they created a binding agreement when they signed a standard offer to purchase form. And remember, the key in that is the standard form. Everybody in Massachusetts had been using this form for years, and everybody in Massachusetts understood the process. You start off with an OTP, and then you move to a P&S. Okay, no problem, until these two Irishmen got together. Then what happened? The Dominicos intervened because they later agreed to purchase the property in question from Tobin. McCarthy and Tobin each moved for summary judgment, and the Dominicos for partial summary judgment. Okay, so let's get into the more, which are the facts, which are more undisputed. That's more of the process of the case. On August 9th, 1995, McCarthy executed an offer to purchase real estate on a pre-printed form generated by the Greater Boston Real Estate Board. The OTP contained, among other provisions, a description of the property, the price to be paid, any deposit requirements, title requirements, and the time and place for closing. The OTP also included several provisions that are the basis of this dispute. The OTP required that the parties shall, on or before 5 p.m. August 16th, execute the applicable standard form purchase and sale agreement recommended by the Greater Boston Real Estate Board. So, as part of this agreement, an action has to take place in the future, which, when executed, shall be the agreement between the parties hereto. In the section containing additional terms and conditions, a typed written insertion. Now, for those of you that are not old enough to realize this, back in 1995, we had computers, but we also had typewriters, and it was a form. And you couldn't do the forms online. We hadn't had DocuSign by that time. All right, so we had to type in these things, and it said, subject to the purchase and sale agreement, satisfactory to buyers, other terms and conditions, that this was subject to the purchase and sale agreement, satisfactory to buyer and seller. It also said time is of the essence. Now, a lot of you see that in a lot of real estate contracts, and you probably don't understand what that really means or why it's in there. It's in there because there are dates and times in the future that things have to happen. So by saying time is of the essence, what we're saying is that those dates and times are requirements in this deal. So don't blow past them. Finally, an unnumbered paragraph immediately above the signature line says notice. Oh, and this is typewritten in. This is not part of the standard form. One lawyer stuck this in there, and it said this is a legal document that creates binding obligations. If not understood, consult an attorney. Okay? That was the McCarthy's lawyer drew that up, and then Tobin signed it that day. But on August 16th, sometime after 5 p.m., Tobin's lawyer sent a first draft of the purchase and sale agreement by facsimile transmission to McCarthy's lawyer. By facsimile transmission. And then for you young kids, that's a fax machine. On August 21st, McCarthy's lawyer sent a letter by facsimile transmission containing his comments and proposing several changes to the contract. So realize that the first draft of the purchase and sale agreement from the seller's attorney came after the deadline for having this document done. That's important. Remember, time is of the essence, but that's going to have that's going to come into play later on in this discussion. Water's so good. Now, the changes laid out that the requirements for good title imposed on Tobin, the risk of casualty to the premises, blah, 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 solicited indemnification for title insurance purposes regarding mechanics, blah, 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 blah. Okay. Now, the next day, the two lawyers discussed the proposed revisions. They did not discuss an extension of the deadline for signing the purchase and sale. Okay? So both parties kept talking, and both lawyers went beyond the date, and the fact that the date had come and gone wasn't even an issue. Okay. On August 23rd, Tobin's lawyer sent a second draft of the agreement to McCarthy's lawyer. On August 25th, a Friday, McCarthy's lawyer informed Tobin's lawyer that the agreement was acceptable. McCarthy would sign it, and it would be delivered the following Monday. Oh, this is where it gets good. This is where it gets really good. On the Saturday, McCarthy signed the purchase and sale agreement. And on the same day, Tobin accepted the Domenico's offer to purchase for $50,000 more. Whoo, wow. Ballsy move, Tobin. Ballsy move, and Tobin. Okay. So, McCarthy, on August 28th, McCarthy delivered the executed agreement and a deposit to Tobin's broker. The next day, Tobin's lawyer told McCarthy's lawyer that the agreement was late and that Tobin had already accepted the Domenico's offer. In September 1995, Tobin and Domenico executed a purchase and sale agreement. Before the deal was closed, McCarthy filed this action for specific performance and damages. Can you imagine? You just said, wait a minute, yeah, the guy hasn't signed the contract. I'll offer you $50,000 more. Oh, I'll accept it. Okay, great. and then the other buyer, clouds the title by filing an action for specific performance. Okay, so who wins? Who wins? Who do you think wins? Well, first off, let's talk about the issues here in this case. All right, they're essentially the Supreme Court, the Supreme Judicial Court here in Massachusetts. This is a state case, not a federal case. The Supreme Judicial Court had 3 issues that they were going to analyze, and I'm going to discuss each one of them separately, and you'll see where the court comes down on each one. It was a unanimous decision on all parts of the issues. So this one's a fun one, because how many times have I even said, offers to purchase are not binding, especially the template that I use. They're not binding. Make offers, make offers, make offers. But be careful. You got to make sure you make the right offer. Okay. Was it the first issue that the court had to decide was it a firm offer? Was there a true meeting of the minds? Was there consideration? Were both parties legal? All those requirements, the 4 necessary requirements for a contract or an offer. Was the offer a firm one? The primary issue is whether the offer to purchase executed by McCarthy and Tobin was a binding contract. Tobin and the Dominicos argued that it was not, because a provision requiring the execution of a purchase and sale agreement, McCarthy urges that he and Tobin intended to be bound by the OTP, and that execution of the purchase and sale agreement was merely a formality. McCarthy, the buyer, argues that the OTF adequately described the property to be sold and the price to be paid. The remaining terms covered by the purchase and sale agreement were subsidiary matters, which did not preclude the formation of a binding contract. The controlling fact is the intention of the parties. Okay. Now, in Massachusetts, remember, like last time we talked about it, we had to go outside of New Hampshire to find case law. In Massachusetts, there was plenty of case law on point. The Supreme Judicial Court could look right within their own courtrooms to find precedent for them. In fact, there was a case called Levinson v. LMI Realty that said it is settled principle of contract that a promise made with an understood intention that it is not to be illegally binding but only expressive of a present intention is not a contract. That was what Tobin tried to rely on, and the court said, nah. Tobin argues that language contemplating the execution of a final written agreement gives rise to a strong inference that she and McCarthy have not agreed to all material aspects of a transaction, and thus that they do not intend to be bound. But that's not what the court decided. Court decided that the interveners argued that McCarthy departed from the customary resolution of any open issues and therefore manifested his intent not to be bound by requesting several additions to the purchase and sale agreement. So in other words, because McCarthy's attorney and Tobin's attorney started negotiating additional terms like the title requirements, etc., then that meant that they did not have a meeting of the minds, and therefore they were not bound by the contract. What McCarthy is saying is that, hey, we had all the necessary requirements to prove to the world that we had a binding offer, we had a contract. And Tobin is saying, no, because after that, what happens if we couldn't agree on the title insurance requirements? Then we couldn't be bound by a contract. And the court went on to say, okay, hold on, let me get it over here. The 4 of 8, 5 of 8. Okay, so yeah. The inference that the OTP was binding is bolstered by the notice printed on the form. McCarthy and Tobin were alerted to the fact that the OTP created binding obligations because it said this is a binding agreement in the OTP. The question is what those obligations were. The Dominicos argue that the OTP merely obligated the parties to negotiate the purchase and sale in good faith. Court said, we disagree. The OTP employs familiar contractual language. It states that McCarthy hereby offers to buy the property, and Tobin's signature indicates that this offer is hereby accepted. The OTP also details the amount to be paid and when, describes the property bought, and specifies for how long the offer is open. This was a firm offer, this acceptance of which bound Tobin to sell to McCarthy to buy the subject property. We conclude on the first issue of whether it was a firm offer that the OTP reflects the party's intentions to be bound. Bam. One strike, two more strikes to go. Now, the issue about waiver. Why do we have the clause, time is of the essence? So we already discussed that, but the waiver, let's talk about that for a second. Courts hold parties to deadlines they have imposed on themselves when they agree that time is of the essence. Well, it said time was of the essence, and they put dates in there. And case law in Massachusetts says that that's important. If you breach those duties, those requirements, the contract fails. That's what everybody thought until those two Irishmen walked into the bar. The August 16th date is a condition subsequent. So we already have a firm agreement. Anything after that is a condition subsequent. And then, of course, you have a condition precedent, which are things that have to occur before the contract can be bound. Without an executed purchase and sale agreement by that date, the OTP provides that the parties' obligations to each other are extinguished. Of course, this is Tobin talking now. Is that what the court agreed to? No. The court said, we are persuaded that Tobin waived the deadline. Tobin's lawyer, acting as their agent, voluntarily undertook the task of drafting the purchase and sale agreement. He did not produce the first draft until after it was impossible for McCarthy to sign it before the deadline. It was seller's attorney's fault. He took too long. He waited until Friday. So in essence, the fact that they continued negotiating and they continued sharing documents back and forth, that meant that date was no longer an issue to the firm offer. And I'm telling you, folks, I said two Irishmen walk into a bar and they change contract law. They change real estate contract law. That's exactly what happened. I bet Tobin's lawyer was advising Miss Ann Tobin that, don't worry about it. You're okay. Everything's going to be fine. Well, it didn't turn out that way. Words and conduct attributable to Tobin signified her waiver of the August 16th deadline. Once there was a waiver, time was no longer of the essence. And they concluded, the Supreme Judicial Court concluded that there is no issue of material fact and that McCarthy was entitled to a judgment as a matter of law. Ooh, second strike. We got one more to go. One more, and McCarthy loses. Okay. And this one's a short one. The issue is one of specific performance. Now, on remand, that means it goes back down to the lower court. The issue of the appropriate remedy will arise. Now, let me just explain to everybody here. I want you to understand what happens. When you're going through your purchase and sale contract, and especially in my client's purchase and sale contract that we use, there's the seller's default and the buyer's default. This is where you're going to see the remedies for the default. And usually one of the remedies is specific performance, essentially telling the seller, hey, you got to sell this thing to me. You know, you don't typically see specific performance as a remedy if the buyer defaults. Usually you just lose the earnest money deposit. One of the reasons why the guy defaulted might be because no bank would give him a loan. So on remand, the issue of the appropriate remedy will arise. A judge generally has considerable discretion with respect to granting specific performance, but it is usually granted in disputes involving the conveyance of land. Okay, now let me explain something. And you hear me say this so many times, at least my students do. Here's the deal. You always have to have local representation, local counsel whenever you're buying property. You have to have somebody, the good real estate attorney in that jurisdiction who knows the law. Because what I found, I was advising a client and through an attorney, who was being represented because they were, contemplating legal action. I was helping the seller. My client's attorney understand, how multifamily works in those situations. And we talked about the remedies in the event of breach, because it looked like the buyer was going to breach. And then I said, well, we want specific performance. And she said, oh, you'll never get that. And this was a county in Tennessee. And she said, oh, you'll never get that. So what do you mean? It's in the contract. They agreed to it. This is specific performance, because now no judge in this county would ever give specific performance as a remedy. But they agreed to it. It's in the contract. Both sides said, yeah, but that's not the way it works down here. Holy cow. So that's why you always have to have local counsel. It is well settled law in the Commonwealth that the real property is so unique, I'm adding my words in here, that money damages will often be inadequate to redress a deprivation of an interest in land. It is therefore proper to allow McCarthy specific relief. So that means that Tobin lost. Tobin lost this case. And that was a bombshell here in Massachusetts, to hear that the Greater Boston Real Estate Board's forms don't work. The court looked at it entirely different way than everybody else had been doing it by custom. And all of a sudden, overnight, these two Irishmen changed real estate contract law. You started seeing all the contracts being changed. And I'll tell you, one of the things is that they added wording, and I'm going to read it to you right now. And I'm going to read you what we have in our offer letters of intent. That the Massachusetts, the Greater Boston Real Estate Board came out with wording that says, the purpose, and this was now became standard wording in the OTP. The purpose of this document is to memorialize certain business points. The parties mutually acknowledge that their agreement is qualified and that they, therefore, contemplate the drafting and execution of a more detailed agreement. They intend to be bound only by the execution of such agreement and not by this preliminary document. That's what you see now in all Massachusetts standard wording. And in our letter of intent, if you go back, after we go through all the terms, we say specifically that it is understood and agreed that this letter is not, capital letters, not binding, and does not constitute a complete and definitive purchase agreement for the properties, but merely evidences the intent of the parties to enter into good faith negotiations, and that's it. So that's why you see that type of wording in these agreements, is because of two Irishmen walking into a bar. Okay, I told you that there was a punchline. Oh, and let me see if I can find. Oh, here it is. Okay, so what you had to do, and I'll just tell you, folks, that's why I love reading case law, because it's like a history lesson. So what you have to do is and of course the beautiful thing about today's legal research is you just click on the hyperlinks and you go right back to the document they're referencing. So I started going down the rabbit hole in this case and started looking at some of the facts, and I got a little bit more color on what actually happened. Get a load of this. The Dominicos closed in the deal. While all this legal ramblings were going on, let me see if I can find the wording. They had to sell the property to McCarthy. The court said specific performance. McCarthy got to buy the house. Get a load of this. $500. Remember the purchase price that we said at $556,000. Is that what we said it was? Oh, where's my note? Here it is. $526,000. Okay. And Domenico comes in and buys it from Tobin for $576,000. And then this case was decided in 1999. Oh, just think about this for a second. This is unbelievable. This is unbelievable. Domenico, 5 years later, finds out from the Supreme Judicial Court that they've got to sell the property back to Tobin for the $526,000. 5 years later, let alone the 50 grand difference. Hey, Ann Tobin, cough up the 50. Think about all the equity that they lost. Was this covered by title insurance? I bet you they couldn't even get title insurance. This title was clouded. I want to find out what really happened in this case. I'm gonna call the lawyer on this case. I have his name. I'm gonna do a little more research, because what happened to Domenico? 5 years later, he had to sell the property back to McCarthy, and he already paid 50 grand more for it. You know, a little bit of shame on him. And here's why. He knew this was happening. He knew this was like no surprise, but he should have never gone to the closing table, because there was still litigation involved on the property. But everybody, all the lawyers were probably telling him, don't worry about it. Don't worry about it. You got to, this one's in the bag. And then the SJC comes back and says, nope, not so fast. Ouch. I am really going to dig down a little bit deeper. Maybe in future calls, I will have a story for you on this one. But that's the case of the two Irishmen that walk into a bar and change real estate contract law. Fascinating case. It's a great one. I think one of the next ones we're going to talk about is Tristram's Landing. Tristram's Landing. That is a place on Nantucket. It's a fractional ownership place. It's not a timeshare or condos. It's a fractional ownership where each person owns 1/8 of a little tiny cottage on Nantucket. But if I remember correctly, that case settles the story of ready, willing, and able. Bringing a ready, willing, and able buyer to the property. Is that when the broker gets paid their commission? So I got tons of them. A lot of these great stories. It's like a walk down memory lane. It's like a history lesson in cases. If anybody has any great benchmark cases that they want me to take a look at, please let me know. Shoot me an email. And that is all we have for today. That is it, folks. Thanks for coming. But I hope you enjoyed this. I did. This was a lot of fun. So I will, don't forget, let me say, I got another one. I'm starting to do these multifamily law schools every Tuesday and Thursday. They're a lot of fun. Come on down, take a look. If anybody has any questions, sometimes we might play Stump the Professor. That'll be a good time. And otherwise, I will see you all next Tuesday. Thanks for coming. Tell a friend. Hit the like and subscribe button. Oh, good. Thanks, Ellie. I appreciate that. Hit the like and subscribe button so I can get these numbers up. I was on another StreamYard session with Nate Dodson, crowdfunding lawyers, yesterday. Talking about our new deal, the hotel to apartment conversion. You can go listen to that one. That was a lot of fun too as well. So please step on up. Good to see you all. Thanks for coming, and we will chat soon. Talk to ya.